Yes, Mr. Kinnear.
Thank you, sir. May I call Mark Anderson?
Right, thank you. Good afternoon, Mr. Anderson. Welcome back. You're going to make the affirmation, I think. Is that right?
I am indeed, Mr. Chairman.
Yes. Well, then,
panel members.
The words are on the screen.
Thank you very much. I'll just get my glasses. Okay. I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Good. Thank you very much. Yes, Mr. Kinnear.
Thanks, sir. Would you mind confirming your name for the record, please?
Mark Anderson.
Mr. Anderson, good afternoon. Thank you again for coming to give evidence to the inquiry. In this module, we'll be looking at the governance of fire safety by the TMO and your role in that, and the role particularly relating to fire safety. Just to confirm again for the record, you've made two statements to the inquiry that deal with events leading up to the 14th of June 2017, and they are, for the record, the first statement dated the 12th of February 2019, which is at TMO 100-48968, which I'll refer to as your first statement. The second one dated the 5th of November 2019, TMO 00847-334, which I'll refer to as your second statement. Mr. Anderson, just some context questions to start off with, first of all. You started in the social housing sector with sanctuary housing in 1992, is that correct?
That's correct.
And you joined the TMO in 2010?
2011.
2011. And before you joined the TMO, did any of your roles involve the management of fire safety?
Yes, a number of them.
And can you just give some background as to what those roles were and the extent of your involvement in fire safety?
I'd held equivalent roles with a number of housing organisations prior to the role that I held with Kensington Chelsea TMO.
And what training did you have to enable you to manage fire safety in social housing before you started work at the TMO?
I can't recall specifically what the training was. Over the years, I'd certainly myself attended a number of either organisationally facilitated, external specialist facilitated, or contractor servicing partner facilitated sessions in relation to legislative requirements, legislative changes, and the way in which fire safety arrangements should be managed. But that was all part of broader health and safety and compliance aspects.
And what fire safety training did you receive whilst at the TMO?
I can't recall specifically what they were. I do recall that the HR team facilitated annual refresher training, some of which did involve fire safety matters. It also included matters relating to asbestos management, electrical safety, lifts, water hygiene. There were a number of seminars that I attended, either self-initiated or through professional bodies that I was a member of at the time in respect of CPD, and things of a similar nature to that, either online or in person.
Thank you. And did you receive any specific training on the requirements of the Regulatory Reform Fire Safety Order 2005 whilst at the TMO?
I recall that there were a number of sessions. I can't recall who facilitated those, but I do remember that certainly one of them was an external party that was in relation to the RRO, the requirements of the RRO, and how that was applied or applicable to social housing.
Thank you. And were you familiar with any of the specific guidance that published by the government in relation to fire safety matters, and in particular the Local Government Association's guidance on fire safety in purpose-built flats, which was published in 2011.
I do recall seeing the LGA guide, apologies, Local Government Association guide, and I do recall there being a number of other summary guides that Department for Communities and Local Government published. Subsequently,
I'll take you through some of those. Did you read the LGA guide? Were you aware of its existence more than that?
I was aware of its existence. I can't recall whether I specifically read it. I'd be surprised if I didn't.
And did you, first of all, were you aware of LACOR's guidance entitled Housing Fire Safety Guidance on Fire Safety Provisions for Certain Types of Existing Housing?
I do recall that being one of the supplementary guides.
And did you receive any specific training on the LGA guide or the LACOR's guide?
I don't recall specific training in relation to those. It was generally captured as much broader fire safety training or awareness sessions.
Did you use the documents to inform yourself about the approach or best practice to the management of fire safety in your work?
As I said earlier, I can't recall specifically, but I think there were general approaches within the social housing sector at that time in respect of fire safety management, and so I was aware of best practice at that time.
Thank you. Can we now turn to your role in the management of fire safety? And if we go in particular to paragraphs 67 to 70 of your first witness statement, which can be found at TMO 100-48968/1515. I'll invite you just to refresh your memory briefly by reading those 4 paragraphs.
Okay.
Now, in summary, just to understand what the scope of your responsibility was, is it right to understand that you're responsible for ensuring that TMO had systems to assess its properties for health and safety risks?
Correct.
And that role included ensuring that fire risk assessments were being undertaken for each relevant property?
Correct.
And it was for the health and safety team to procure fire risk assessments and ensure that they were carried out correctly?
That was their function within the TMO, yes.
And you yourself relied on the health and safety team's reports and feedback in relation to the content and adequacy of FRAs?
Yes.
And particularly, you were not responsible for reviewing the findings of FRAs, is that fair?
That's correct.
Or to check that the actions arising out of the FRAs had been undertaken, except in relation to your own department?
Only if they were escalated to me.
Could you give us an idea what type of issues, actions identified in FRAs would be escalated to you?
Generally speaking, the process was that the health and safety team would have reviewed the FRAs and any recommendations coming out of that. They would have ensured that they were put onto the systems or brought to the attention of individuals within my directorate to action. Usually the type of escalation I'm talking about is if there was an inordinate delay to the progression of that work.
Thank you. And if, following on from that, if you were aware that properties weren't being fire risk assessed, would you be the one who was ultimately responsible for taking action to ensure that they were fire risk assessed?
My understanding was that remit sat with the health and safety team. It would certainly be an obligation on me, however, to point out that I thought one had not been done, or a number had not been done.
And flowing on from that, if you were aware of a fire risk that hadn't been addressed, ultimately you'd be responsible for taking action or ensuring that the relevant individual took action?
Yes.
Although you're responsible for ensuring an appropriate system was in place, is it right to say that you had no or little knowledge of the conclusions or reports arising from individual FRAs?
That's correct.
or the scope of those reports?
Correct.
How frequently the FRAs themselves were carried out?
Correct.
Or indeed by whom?
My understanding was that the FRAs at the time I was employed by the TMO was that they were undertaken by Mr. Carl Stokes.
Okay. Now, given the nature and extent of your responsibilities and what you didn't know, could you help the panel on how you could exercise effective responsibility for ensuring that the TMO had adequate fire risk assessment procedures in place?
Fire risk assessment procedures or fire management procedures?
Well, fire risk assessment procedures is the question I asked.
So in terms of the fire risk assessment procedures, there was a policy that set out the requirements in relation to fire risk assessments. That was quite clear that was a function performed by the health and safety team. The health and safety team, prior to my starting, had procured the services. I can't recall the name of the consultancy.
Are you thinking of Salvis?
No. This is the one that Mr. Stokes was procured through. I can't recall the name of his consultancy business. And that there was a specification of requirements. He was engaged to provide that service. Those fire risk assessments were in accordance with guidance at the time, and they were managed and administered by the health and safety team. Actions arising from those fire risk assessments were then notified by the health and safety team to individual parts of the organisation with responsibility for ensuring that those actions were closed.
So it was the existence, if I can summarise your evidence and say so if this is done unfairly, you were satisfied that as a result of the arrangements under the policy, that appropriate procedures were in place for discharging obligations in respect of fire risk assessment?
Yes, because it would be the policy that I would refer back to in terms of what was the policy, what were the requirements, what was the process.
Now, you're attempting, I think, to draw a distinction between FRA, fire risk assessment, and fire management. Would you explain to the panel the distinction you're seeking to apply here?
Fire management is a much broader process, and fire risk assessments are part of a fire management strategy or process.
Okay. Now, if we can turn to paragraph 19 of your second witness statement, which is at TMO 008473334/5. You say this: I was not involved in overseeing the TMO's fire risk assessment programme. However, if an action arising from the programme was assigned to my directorate, this would be progressed by the respective teams under my management. I had no role in ensuring that the FRA programme complied with the regulatory reform fire safety order, as this was the responsibility of the TMO's health and safety team. Now, in paragraph 67 of your first statement, you say that you're responsible for ensuring that an FRA programme was in place. Yet here you seem to be saying that you had no involvement in overseeing the programme. First of all, is there a difference between what you're saying in your first and second statements? If so, can you explain that difference?
Yes. So yes, there is a difference. In the first statement, that relates to my role as director of ultimately assets and regeneration, and needing to be satisfied that there was an FRA programme in place. In this statement, at paragraph 19, what I'm actually talking about is the programme itself, the delivery of the programme of FRAs, and that was very much the remit of the health and safety team.
Now, your responsibility, and apologies for just going back just to clarify this, but your responsibility appears to be ensuring that actions highlighted by FRAs would be completed by the team to which the action had been allocated. I think You're nodding, is that fair?
That's correct.
Would you also then accept as the consequence that if an action had not been completed or had not been completed within the specified time, that too was your responsibility for sorting out?
Correct. And that goes back to my earlier point about those issues that were escalated. Because generally what would happen is they'd be assigned to an officer. If that wasn't resolved to the health and safety team's satisfaction, it would be raised with the manager. If that wasn't then resolved, it would be escalated to me.
So you weren't so much monitoring compliance with FRAs, it came across your desk when something wasn't done, i.e. your role was reactive rather than proactive?
That's correct. My understanding is that the monitoring was undertaken by the health and safety team and reported up through, there were a number of health and safety fora within KCTMO.
Thank you. Looking further on the extent of your responsibilities, first of all, were you responsible for investment in fire safety measures?
Yes.
Planned maintenance of fire safety measures?
Yes.
Management of fire safety measures in TMO or RBKC assets or stock?
Correct.
Responsive repairs to fire safety measures?
No.
And why do you say that was outside your remit?
There were two separate teams. There was assets and regeneration, and then there was, I'm trying to recall what their title was, but they dealt with responsive repairs. They weren't part of my directorate.
Did you have a responsibility to ensure that any contracts let by your team would ensure compliance with fire safety legislation and requirements?
Where applicable, yes.
And how did you ensure that compliance?
In relation to your last question?
In relation to the contracts, yes.
Generally, they were included as requirements within the specification and the tender documentation requirements.
And so that's the sort of general requirements you see in contracts saying you must comply with the Health and Safety at Work Act, etc. Is that what you've got in mind?
I think that's a very basic approach. I think in some instances you could be a lot more sophisticated and detailed than that.
Were you?
Where it was necessary, yes.
And what types of contract would it be necessary to be more specific and sophisticated?
For me, if there was one that particularly related to fire safety matters or fire safety management, then I would expect there to be a lot more detail about the expectations of the client as an organisation of that service provider or consultant.
Thank you. Now, can we turn to the TMO's health and safety policy, which can be found at TMO 100-31076. And we can see in the bottom left-hand corner of the first page, it's dated December 2012. And so that would be current just as you were coming to the end of your time at the TMO, is that right?
Correct.
Thank you. Now, if we could go to page 3 and paragraph 2.8 in particular, and that sets out the scope of responsibility of the Operations Directorate. And it says the Directorate is responsible for, first, resident safety in particular, in the areas of fire safety, gas safety, electrical safety, Legionella prevention and water quality and lift safety, taking a joint role with the health and safety team in managing asbestos at work, monitoring the health and safety performance of the contractors under their control, and organising an asset and regeneration and repairs health and safety group consisting of all technical managers and health and safety to meet at least bi-monthly and provide a forum for discussion and monitoring health and safety issues across the service area. Now, at first blush, that would suggest that the Operations Directorate, your directorate, had a significant operational involvement in health and safety. Would you agree?
Yes.
In particular, a responsibility for resident fire safety. Would you agree with that?
Yes.
And that would have required significant competent management from the operational side.
Correct.
And significant oversight from you, presumably, also.
At an operational level or at a strategic level?
Operational level first.
To an extent, yes.
Yes. And what was that extent?
I in turn would rely on my service managers to have much more operational involvement and knowledge of the detail around fire safety.
And what was the extent of your strategic oversight of these responsibilities in relation to resident fire safety?
It would be much more about were we broadly meeting the requirements of health and safety policy? Were we broadly, as an organisation, looking to evolve the service so that we addressed future demand or arising legislation, etc.?
Thank you. Now, one of the areas for which you were responsible, your directorate, was the TMO's fire protection systems policy. Is that right?
As in the writing of the policy?
Writing and application. Take writing first of all.
Yes, with support from other parts of the organisation.
Well, let's look at minutes from the TMO's Assets and Regeneration Health and Safety Group meeting in May 2012, and we can find those at TMO 00869-805. Now, we see in the top of that it was chaired by a J. Borrer. Can you remind us, first of all, who he was and what his position was?
John Borrer, and he was policy and performance manager within the Assets and Regeneration team.
And would you have chaired that meeting at any time during your tenure at the TMO?
I may have chaired the initial meeting that I attended.
So when you started in 2011?
Yeah. Mr. Chairman?
Yes.
Would it be okay if I took my jacket off? It's
Of course it would, yes.
a bit warm. Thank you.
I should say, Mr. Anson, if you need a break at any time, just shout.
It's just rather warm.
No, you make yourself comfortable.
Thank you.
And you've got some water there, haven't you?
Yes, thank you. Thank you very much.
Right.
Mr. Anderson, you said you may have chaired the initial meeting. Why did you not chair the subsequent ones?
It would appear I delegated that to John Borrer.
And was there a specific reason for doing so?
John's role was very much looking at policy and the performance and making sure that we were according with those requirements. If I recall correctly, there was, so this was Assets and Regeneration, there was another health and safety group, which I believe was TMO-wide. And there was also a performance group, both of which I attended on occasion.
But didn't chair?
No.
Now, if we could turn to page 5 of these minutes, in particular item 11.0. And then we see policy procedures new/currently under review. And we see it 11.7, fire protection systems, final draft with MA for final comment. First of all, presumably that MA is you.
Correct.
Yes. And if we might be useful to look at that policy, and the version I'd like you to look at is dated the 10th of February 2012, and that could be found at TMO 00870-933.
Could I just check the date of these minutes again?
Of course, yes.
That was May, was it?
Exactly so.
Thank you.
May 2012. And so this is dated, as you see in the top, 10th of February 2012. And what I might do is just invite you to skim read it briefly. It's a very short document. But the point I'm going to put to you is that there is no mention in that policy of any fire strategy or the TMO health and safety policy. And I'd be grateful for your explanation as to why those matters would not have been addressed here. But I'll just let you satisfy yourself that those matters aren't mentioned there.
Okay. Okay. Thank you. Okay. Right.
Now you've had a look at that, Mr. Anderson, can you explain why that document didn't refer to the fire safety strategy or the TMO's health and safety policy?
I can't. I can only presume that as this was the TMO health and safety policy was an overarching document and this fed underneath it. In hindsight, I think it should have made reference to them.
And similarly, looking at the fire safety strategy in particular, given that the subject of this policy is fire protection systems, one would ordinarily expect, is it fair to say, reference to the fire safety strategy in such a policy?
I think that would be a good thing, yes.
And again, for the avoidance sake, you can't explain why it's not in there?
No.
Now, could we go back in this document to the second page and paragraph 1.2 in particular? And if that could be expanded. And there we have a list of 6 systems identified. Can you help us again? In a policy concerned with fire protection systems, there is no mention of the smoke control systems. Can you help us as to why not?
No, I don't know why it's not specifically highlighted as or identified as a category.
Can you help us to why there is no detail regarding planned preventative maintenance, particularly to communal fire doors or door closers?
My recollection is that the fire door closer servicing and maintenance and the fire doors themselves were captured under the responsive repairs maintenance contracts.
And in relation to lifts, because there's no mention of lifts there either, where would that be captured?
My recollection was that there was also a lift policy or procedure.
There's no reference to those policies or procedures in this document, though, is there?
No, there's not. Well, certainly not from what I've seen.
And there's no reference to any other policy documents, whether by reference or encouragement to read when looking at this policy?
No, there does appear to be an overall absence of cross-referencing to other policies.
Would your department have been responsible for overseeing the work, planned preventative maintenance service visits in relation to these 6 identified systems?
Yes.
Now, staying on that page, can we look at paragraph 2.1 under the heading Purpose? And it says the purpose of this procedure note is to identify the action to be taken by the TMO following a report of a breakdown or malfunction to any element outlined in 1.2 above. Now, the purpose of this procedure is reactive, not preventative. Is that a fair summary? Looking at what's set out in paragraph 2.1, it's following a report of a breakdown or malfunction.
Yes, I'm just wondering where the procedure note is, because you referred to this as a policy.
Would you want to go back to the covering page?
If that would be possible.
Yes. So it's policy and procedure.
And procedure, yeah. Okay.
So if we go back to 2.1,
Yep.
would you accept, looking at what is set out in 2.1, that the procedure is reactive, not preventative?
In the context of that sentence, yes. Because as you pointed out, it's about action taken following report of a breakdown or malfunction.
And would you agree that there's no reference to any other document which sets out the regime for routine maintenance, inspection and testing? Would you like to refresh your memory?
Oh, I disagree that there's no other documents. There are.
The question wasn't that. the question was, would you agree that there's no reference in this policy and procedure document to any other document which sets out a regime for routine maintenance, inspection and testing?
Well, on the 6 points above, there is reference to planned preventative maintenance, and there is a schedule, monthly, quarterly and annually, for sprinklers, for example.
And you'd say that's sufficient?
For a policy document in its basic sense, yes. I would expect as well that there are other documents, the contracts, for example, which set out in much more detail the planned preventative maintenance regime and the site visit regime and what was required of those on a routine basis.
Those documents aren't referenced here, though, are they?
They're not, and I wouldn't necessarily expect them to be referenced to that level of detail. But I think it would have probably been useful to have made reference to the fact that there were contractual arrangements that set out the detail.
Can you remember who drafted this policy and procedure note?
My recollection in relation to all of the policies were, particularly those relating to assets and regeneration, was that John Borer took the lead on them with support from other parts of the corporate structure within the organisation.
But ultimately, were you responsible for signing it off?
I was responsible for agreeing it and then taking it up through executive for approval.
And we can go back, just to remind you, could we go back to TMO 00869805? And if we go to page 5 and item 11.7, and if we look at Fire Protection Systems' final draft with MA for final comment, you had an opportunity to make good any deficiencies in the draft before it was signed off. Would you agree with that?
Correct.
Can you therefore explain why there are no detailed or no reference at all to the fire safety strategy and the health and safety policy?
I can't.
And when you accept it, it would be prudent and best practice to do so?
Yes, indeed.
And you can't explain why there's no more detail other than regularity regarding the maintenance, inspection, testing regimes. Is that fair?
Could you repeat that, please?
Yes. Are you able to provide an explanation as to why you made no comments to ensure that there was more detail other than regularity about routine maintenance, inspection and testing of those 6 systems set out in the policy?
I'm not able to recall what comments I did make, so I can't answer your question.
Ultimately, who is responsible for ensuring that this policy and procedure document is sufficient to meet the TMO's legal obligations under the 2005 Fire Safety Order?
I'm not sure who the delegated responsible person was within the TMO. I don't recall who that was.
Would it have been Janice Ray, or would it have been higher up beyond her at executive level?
I would have expected, from my knowledge of the TMO at that time, that it would have been a member of executive.
Ultimately, would it have been the CEO?
It may well have been, but I can't say for certain that it was. And just looking at 11.9
Yes.
on that document, there is reference there to the Health and Safety Committee, which was the TMO Health and Safety Committee, and these documents being taken to that committee for sign-off and adoption. So it may be that it's in their terms of reference.
And can you remember, did Janice Ray, in your recollection, sit on the Health and Safety Committee, or was it the executive responsible director for health and safety?
My recollection is that Janice attended. I don't know if she was a standing member.
Thank you, Mr. Now, if I can return to the topic of FRAs, actions that came from significant findings in the action plans of Carl Stokes were appended to each of the FRAs he prepared. Is that correct? Or is that your understanding or recollection?
From my limited awareness of individual FRAs at the time, yes, that's correct.
Did you ever see either the FRAs themselves or the significant findings and action plans? Or by the time it got to you, was it just specific matters identified for you?
On occasion, I did have sight of individual FRAs, and that generally arose out of an inquiry of Janice Ray about a particular FRA. As to the schedule of actions arising from that, either individually or globally, no, I didn't view those.
Would you have been aware that Carl Stokes colour-coded the actions in terms of priority?
My understanding was that he did adopt a red, amber, green type approach.
Did the information that was given to you include colour coding of actions by priority? So you knew how far behind they were or whether it had been done at all, and the nature of a delay, if that was relevant?
I don't recall seeing that in any of the escalations that came to my attention.
Did the escalations that came to your attention, would they include details of timescale, when something was meant to have been done, what's happened, and why there's a delay?
Yes, they would.
Would you accept that the fact an action has been identified in an FRA may indicate an increased risk to residents?
My personal belief is that any action that's identified in FRA is a risk.
And would you accept the consequence that an action that was left unfinished timelessly may mean that the TMO was in breach or potentially in breach of its legal obligations under the fire safety order?
It could do, yes.
And potentially subject to prosecution?
Yes.
And your team had a responsibility to clear actions allocated to it by health and safety. Is that correct?
That's correct.
Now, could we turn to TMO 008 99965? Thank you. And these are minutes of an executive team meeting on the 7th of July 2011. And if we can go to page 2, you're not present at this meeting, I should make clear. Item 3, Health and Safety Annual Report. And then going over to the next page, the second bullet point from the top. It says, Mark Anderson and Andy Marshall would attend Health and Safety Committee for Asset Management and Engineering as there was concern about the level of attendance. There was a tendency for staff to think of this area as solely Janice Ray's responsibility. Did anyone raise with you a concern that health and safety was treated solely as Janice Ray's responsibility?
I don't recall that conversation.
Do you remember any mood or a general feeling that it was being treated solely as her concern rather than across the group?
I think, and I can only answer for assets and regeneration, or assets, investment and engineering as it was at that time, that there was a general view among some members of the team that anything to do with health and safety was the responsibility of the health and safety team. And over a fairly short period of time, they were re-educated on that matter.
Who were those individuals, first of all?
I can't recall exactly who the individuals were, but I am aware that there was a general view from some people within the team that if it was a health and safety matter, right, it's health and safety team, rather than actually we all have a role in health and safety and ensuring that risks, etc., are identified, actioned and mitigated.
Can you remember who led the re-education, to use your phrase?
I certainly recall leading some of that.
Did anyone else assist you in that endeavour?
Janice raided and Lornette Pemberton.
And by the time you left in January 2013, did you feel that those efforts had been successful to a lesser or greater extent?
There'd certainly been a significant improvement in taking ownership and individuals recognising their role in the process. Had we resolved everything? I don't think any organisation can say it ever resolves everything, but it was very minimal.
Would you have attended the TMO Health and Safety, these meetings, as opposed to the sort of asset and regeneration health and safety group ones?
So this appears to be the TMO Health and Safety Committee. I do remember attending some of those meetings.
And would there be other formal, informal groups you'd attend at which fire safety matters would be discussed? Can you remember now?
There were certainly discussions around fire safety and health and safety and compliance more broadly. They were starting at my directorate with my management team, or so the managers within my team. Whenever we had our team meetings, health and safety was a standing item on our meetings. If there was a need to support that manager with their team, then there would be discussions there. I know there was the assets and regeneration and the repairs health and safety groups. I only tended to attend those if I was asked to attend. The corporate health and safety ones, which I believe this one is referring to, again, if I was asked to attend, I would be doing that. A lot of the conversations I would have around health and safety tended to either be with Janice as the manager for the health and safety team, or at this particular point in time with Lornette Pemberton.
And can you remind us of what her role was at the time you were at the TMO?
She was, I believe it was Director of People and Performance.
Okay. Now, could I ask you now to look at minutes of a TMO Health and Safety Committee meeting on the 21st of November 2012, and we can find those at TMO 100017883. Now, mindful of that date, Mr. Anderson, 21st of November 2012, would that have been the last TMO Health and Safety meeting you attended before you left in January 2013?
It doesn't have me down as an attendee.
Sorry. Fair point. Would you have attended one after, between November 2012 and January 2013?
I may have done if there had been one.
Now, can you look at item 1 on the first page, which says, many of the items on the FRA action plans do not appear to be being progressed with the necessary degree of priority. This continues to give concern and is likely to be highlighted by the imminent council audit of our FRA procedures. And then the action in the far right box, exec team to note and discuss with their teams. Now, can you help us with how this system was meant to work? Was the intention that Anthony Parks would raise it executive team level first of all? Are you able to flesh out the bare bones of what's set out here?
Given that Anthony Parks is the chair and was the executive team member there, I deduced that he would have the conversation with his fellow executive directors, and that they in turn would discuss it with their directors, assistant directors, heads of service.
Am I right? Apologies, my memory may be wrong. Was Sasha Jevons your exec director at that stage, at the end of 2012?
I can't remember exactly when the executive director title was adopted. It would appear that it was towards the end of 2012. So on that basis, yes.
And if that's so, mindful of the caveats you've given, Did Sasha Jevons ever discuss this question, the absence of a necessary degree of priority to FRA actions, with you before you left?
I do recall that there were instances where FRA actions were discussed at Sasha's management team meetings. I don't recall us having a one-to-one discussion about it.
And can you remember any meeting or any discussion when she said to you, what are your proposals for sorting out any backlog insofar as it concerned assets and regeneration?
As I said, there were discussions at the operations directorate management team. I can't recall what was actually said at those. I do recall that there were discussions around fire safety.
Okay. Can we next look at minutes from the TMO Assets and Regeneration and Repairs Health and Safety Group meeting on the 13th of December 2012, i.e. just before you left? They are at TMO 1001850. Again, you're not at the meeting, but would you have received and read the minutes?
My recollection is that I did get copies of the minutes, and I also received. I had this as a standing item on our management team agenda. So these were, and anything flowing out of this would be fed back by John Bora or Mike Hallamond or Ricky Sams.
Thank you. Now, if we could go to page 3, and in particular item 6.0, which is fire risk assessment progress update. And if we look at 6.2, and if that could be expanded, outstanding actions, it says a significant number of actions remain outstanding, which is a cause for concern. All were asked to ensure that these are progressed with actions progress evidenced and confirmed to health and safety team ASAP, action all. Now that minute would suggest that certainly as at December 2012, a backlog had arisen within the A&R department. Would you accept that as a fair summary?
Would you mind if we just went back to the first page?
Of course.
The reason I asked to go back to the first page, I just wanted to check that it's not just assets and regeneration, there was repairs as well. Please go to the next page, thank you.
To the page we were looking at?
Thank you. That's it. Sorry, your question again?
Would you accept that certainly by December 2012 there was a significant backlog of FRA actions attributable to the A&R Directorate?
From that minute, it is stating that there are a significant number of actions that remain outstanding. What it doesn't say is whether they're to do with assets and regenerations and repairs. I suspect that it was to do with both. So it may have been day-to-day responsive repairs as well as planned preventative maintenance or capital investment aspects.
The absence of distinction between A&R and repairs generally would suggest that it applied to both, wouldn't it?
Yes, and I accept that contention.
Can you recall at this stage what actions were in fact taken from December onwards before you left the next January to deal with the backlog?
I can't recall exactly what action was taken. I could outline what I believe I would have done.
That would be, can we deal with, first of all, are you able to say that action was taken to deal with the backlog of FRA actions at the end of 2012?
On reviewing these minutes, I would not have not taken action.
But can you identify what that action was, though?
I can't give the specific detail because I can't recall that. However, what I would have been doing was sitting down with my management team and individual managers and their teams once we'd established, right, what actions are sitting with you, why are these outstanding, what's the proposal for resolving them, and how that gets carried forward. Not only that, I'd be expecting them, as part of that process, to feed back into the health and safety team as well.
Apologies, it's some time, 8 or so years ago now. When you handed over to your successor, can you remember whether you briefed on what you were doing to clear the significant backlog of FRA repairs in your, or I should say, the backlog of repairs in relation to your department?
I recall having 2 or 3 meetings with Peter Madison, whom I presume you're referring to.
Yeah.
I had 2 or 3 meetings with him. I did do a briefing pack, which I shared with Sasha Jevons. I don't know if that then got shared with Peter Madison, because there was a gap between us, my departure, his arrival.
A backlog at January 2013 tends to suggest that the processes for monitoring and implementing FRA actions for your department was inadequate, or at least not working effectively. Is that a proposition with which you'd agree or not?
Yes, I would. And that's primarily because the data sat in lots of different locations. It was quite cumbersome.
Could we look at that in slightly more detail, Mr.
Sure.
Ransom? Because that's interesting, because it would assist the panel in understanding, looking now, what you considered the problems to be as to why a backlog of actions had arisen.
I think that probably the biggest one was in relation to the time frame that was being set in FRAs for resolving an action. And that...
Are you basically saying it was too tight?
It wasn't realistic. It didn't recognise how much time certain things would actually take. So, for example, on a lot of the mechanical systems, you mentioned automatic opening vents earlier, smoke control systems. A lot of the systems were over 30 years old and required bespoke manufactured parts to carry out repairs. There's a lead-in time to those sorts of things. And so when you get an FRA action that says has to be completed within 7 days, that just wasn't achievable.
But what happens, though, in respect of a system where the priority, the FRA, the risk assessor had concluded that it was a high priority action? He's concluded that, say, for example, 7 days is necessary and reasonable, bearing in mind the risk. How do you ensure that that risk is eliminated or mitigated within the time frame advised by the FRA?
Yeah, and that's where you then start looking at interim measures. You know, is there something we could do as an interim arrangement? Do we ramp up the number of inspections we're doing so that we have daily inspections as opposed to weekly or monthly inspections? So those types of mitigating measures.
One of the earlier reasons you were identifying for there being a backlog was information being held in disparate silos, for want of a better phrase. Sorry, I'm putting words into your mouth, within the organisation. First of all, is that a fair summary of the point you were making to the panel?
I accept your analogy of silos.
Yeah. And given that you're at the TMO for a period of time, sort of nudging 2 years, first of all, what had you done to make your points, your concerns about the timing of FRA actions, presumably to Janice Ray?
I'd had conversations with Janice and Lornette about the timeframes being set around certain elements. And I know that my managers had discussions not only with Janice Ray but also with Mr. Stokes. Generally speaking, the managers, they met with Mr. Stokes whenever he came into the office, and certainly on a monthly basis. And that was part of the way in which they provided him with satisfaction that planned maintenance regimes were in process or being completed. In terms of the other actions, so from my perspective, there was Academy, which was the housing system, W2, which was a a document management type system. There was Keystone, there were spreadsheets, there were contract managers, project managers, engineers' diaries, all of which were holding data in relation to different aspects of the service. And the ultimate goal was to get all of that migrated into 1/2 locations, not the vast number that existed at that point in time.
If I can stop you there, Mr. Anderson. You mentioned, let's go back to the timeframe and FRAs. The discussions you were having with Janice and Lornette, were they verbal discussions as opposed to email discussions?
They may well have been both.
Can you remember when you first raised timing issues with health and safety and Lornette?
I can't remember a specific date. I certainly know that it was in my first year of being at KCTM.
During the course of 2011?
Yes, yeah.
Did it cause you sufficient concern that you yourself felt it had to be escalated to your executive director?
I recall that there was a broader discussion about data and the locations. I don't recall there being a need at that point in time to escalate the issue about timeframes being set within FRAs, because that was a conversation being had with Janice, with Lornette, and also with Mr. Stokes, and trying to set the context within which he could have a better understanding of the constraints we were or challenges we were facing. But it was also looking at what mitigating measures we could potentially put in place as well.
Looking again at the information point, it being held in different silos, you said there was a broader discussion. First of all, was there a recognition that the disparate spread of information was an unhelpful state of affairs? And if so, when was that first identified? What's your knowledge?
That discussion was in 2011. I believe that the organisation had been having discussions prior to my joining, because there were certainly, forgive me, I'm trying to remember the name of it. It was an electronic document management system that was being talked about as a potential solution. Within assets and regeneration, there was also, we were talking about, Keystone had recently been procured and implemented. That had the potential of being developed further. Keystone was an independent company at that point in time, and they were, through their user group, they were talking about having a compliance module. So it was exploring those types of solutions that would aid us in streamlining the process, making it much more efficient, and also making our data capture much broader and much more accurate.
Do you remember Janice Ray making the point that the disparate spread of information was impeding the efficient discharge of health and safety obligations?
I don't remember her making that specific point, no.
Did she ever make the point that the disparate spread of information was preventing the efficient and timely closing down of FRA significant actions?
Yes, she made that point. I made that point. Lornette made that point. And that was what led us to that conversation about, right, how do we resolve this? How do we speed that process up?
And so by the time you left in January 2013, first of all, in respect of timing of FRA actions, did you feel, from your perspective, that there was a greater sensitivity to practical demands in relation to timings as recommended by Mr. Stokes in his FRAs?
I wouldn't necessarily say there'd been a reduction in the timing in his FRAs. I certainly, from the conversations I'd had with Mr. Stokes, there was a better understanding of the challenges that we were facing, and there was a recognition that in some instances we were putting interim measures in place.
And in relation to the disparate spread of information point, did you consider that when you left in January 13, steps were being taken to address that problem?
Certainly, yes, because I know the electronic document management system, there'd been progress and traction on that side. On Keystone, there'd been steps forward there. I think in 2013 there was a planned enhancement and upgrade to Keystone that was envisaged as well. So that was part of the work we'd done in 2012.
Thank you. I'm now going to turn to a different topic, which is fire door replacement.
Okay.
Now, in your first statement at paragraph 13, you referred to the flat fire door replacement programme and stated, for which I had no direct responsibility. Was the programme carried out under the auspices of your directorate?
My recollection, both from my experience of it and from guidance I was provided by Russell Thompson, who was there immediately prior to me joining, and Lornette Pemberton, was that Assets Investment and Engineering at that point in time was providing contract management and project management support to the health and safety team, and that it was their programme.
So support,
Yes.
rather than responsibility.
Yes.
And did it flow from that those managing the project did not report to you?
That's correct.
Do you think that your directorate had an obligation to ensure that the programmes were carried, insofar as you're providing support, that the flat door replacement programme was being carried out effectively?
I don't know whether it was being carried out effectively or not. Certainly what I did notice throughout 2011 was that there was an increasing need for assets and regeneration involvement and support to facilitate the conclusion of that programme.
Now, Abigail Acosta was the project manager for the programme, is that right?
That's correct.
And when you started, she reported directly to you?
There was the assistant director post was held vacant for a period of time, so there was a period of time where I directly managed the project managers.
And then Mike Hallamond started and she reported to him, is that right?
That's correct, yeah.
And can you remember for how long now you were managing Abigail Acosta?
It was a number of months, but I can't recall exactly how many.
When you started in post, did you ask Abigail Acosta to brief you at all on the scope and progress of the programme?
When I joined KCTMO, I received a briefing. In fact, I received a number of briefings in the run-up to joining from Russell Thompson. I then met with each of the individual project managers and service heads to understand from them what their challenges were, also what their workload was, etc.
I'm sorry to interrupt, just focused on Abigail. Sorry.
Yes, we would have touched on that particular project or program in terms of, and even from her perspective, I recall that she very much saw it as supporting health and safety to deliver that program.
And so was your contact with Abigail Acosta not just limited to those few months when she reported directly to you, it was throughout the course of the programme whilst you were at the TMO?
There were some issues that arose subsequent to Mike Hallamond starting, which Mike and I had discussions about, Abby and I had discussions about, so yes.
And what were those discussions? You say discussions about Abby. Tell us what they involved.
The one that primarily sticks in my mind is the treatment of leaseholders' flat entrance doors.
We'll come on to that later,
Yeah.
but thank you. So after Mike Hallamond joined, would your contact with Abigail Acosta be as and when she required support from you?
I mean, yes, although I would have expected that she would have had an initial discussion with Mike.
And did you require her proactively to report to you once Mike Hallamond had come into post? in a sort of proactive sense?
I think my approach with any of my team members was that I was accessible to them. If they had issues of concern, they could come and talk to me about it, regardless of where they were in the hierarchy of the structure.
Flowing from that, can you give the panel an idea of how frequently Mike Hallamond would report to you in relation to the door replacement programme, just in relation to that programme?
Mike and I would have certainly weekly sit-down discussions where we may touch on issues, and we certainly had, as a management team, we had monthly formal meetings as well.
And would the door programme would be discussed in those meetings with you?
Yeah.
What was your assessment of Abigail Acosta's competence and performance as the project manager of the door programme?
I mean, Abby seemed to be very competent in terms of managing a project. She didn't necessarily have the technical understanding about fire doors or actually I should say fire door sets, because there is a very distinct difference. But she was willing to learn.
And how did that sort of lack of technical understanding manifest itself in relation to door sets?
I recall on one occasion having a discussion about what our specific requirements were in terms of the fire door set, and making the point that as a minimum, and I stress minimum, it should be an FD30S.
And you remember that explicitly, do you?
I do.
Can you help us? It's a difficult question in relation to timing. Can you remember when that conversation took place?
That would have been in 2011.
Relatively soon after you joined?
Yes, yeah.
Do you think Abigail Acosta adequately managed the programme in your view?
I don't recall having any concerns, so yes.
Did you take any steps to ensure that Abigail received further training in relation to the health and safety aspects of her job, or in particular the fire safety regulatory demands that apply to door sets?
One of the things I did in 2011 was, I can't remember who it was that the People and Performance Department engaged. They engaged an external consultant at my request to do RRO training for all members of the team. And for some that was a useful refresher, for others it was a little more in-depth. Abby was one of those. The other thing I was quite confident of was that once Mike Hallamond was in the role, was that he would have a much more in-depth ability to deal with any issues that were arising.
Did you ever have cause for concern that she did not have an adequate understanding of the health and safety aspects of the project manager role for this programme?
I think she had an understanding of what they were, so no.
Were you familiar with the KCTMO Health and Safety Quick Reference Construction Work Information Guide?
I don't recall it.
If we bring it up, the seeing it might prompt a memory. TMO...
Mr. Kinnear, I'm loath to interrupt you, but I think at some point we might need to take a short break. This may not be a convenient moment, you'll tell me.
Actually, let's take it now. The convenient is as it can be. If we take the break now, sir?
Yes?
Yes.
Well, I think it is time we had a break, Mr. Anderson. We'll stop now. We'll come back at 20 to 4 and continue then, all right?
Thank you, Mr. Chair.
And I have to ask you, as I ask everybody else, please don't talk to anyone about your evidence or anything relating to it over the break. All right?
Certainly.
Thank you very much.
Thank you.
20 to 4.
Thanks, sir.
Okay. Yes, would you ask Mr. Anderson to come back in, please? Right, do take your jacket off, yes.
Thank you very much. Save me asking.
All right, ready to carry on?
Yes, thank you.
Yes, thank you. Yes,
Mr. Anderson, thank you. Before we broke, slightly before we broke, we were discussing interim measures that sometimes you take pending full completion of an FRA significant action. Can you give us an idea of, or give us some evidence regarding instances where interim measures were applied in relation to fire protection systems?
Certainly. The one that springs to mind is a fire alarm panel that, because of its age, the technology embedded within the panel can't be repaired, requires a replacement, and I'm trying to recall the name of the contract. I think it was RGE, where we worked with RGE to actually have a number of temporary panels that they could install, and it was very much accepted that that was a temporary measure whilst we were waiting for a replacement panel to be manufactured and then subsequently installed.
Thank you. Immediately before the break, we were discussing the fire door replacement programme. Can you confirm for me the steps that were taken to ensure that the TMO compiled, reviewed and completed a health and safety file for the flat door replacement programme?
I can't, because I didn't get into that level of detail.
Would be that something which Abigail Acosta should be able to help us with?
She would have supported that process, and as I was saying before, my view was very much the health and safety team were the programme owner, and that was predicated on the guidance I'd received from Lornette Pemberton and Russell Thompson.
And you don't remember any queries or requests for advice or guidance coming to you from Abigail Acosta regarding the health and safety file for that flat door programme?
I recall her having conversations with me and with Mike Hallamond. I think it was later in 2011, maybe early 2012, just in general terms about that being an output from the programme, but not any detail around that.
Can I now turn to a separate topic, which is leaseholder front doors, which you adverted to earlier on in the evidence? Could we look first at CST quadruple 01607? Now, this is a chain of emails that begins at the bottom of page 2 with an email from Keith Mott of the Grenfell Leaseholders Association, which was sent on 13th of June 2011 at 15:05. It was subsequently passed to Abigail Acosta to deal with, and she copied you into the correspondence. And if we go to the first page of this chain, we can see that in the middle of the page that you emailed her on the 13th of June at 16:25, and I'll just let you briefly read that so you refresh your memory, Mr. Anderson.
Okay.
Now, was June 2011 the first time you'd considered or been required to consider whether leasehold doors would need to be replaced?
I don't think it would have been the first time I'd have expected leaseholders' doors to be replaced.
But whether you'd had to consider the issue?
In this context, without seeing the rest of the string or any prior ones, it would appear this is my first engagement in that discussion.
Now, in this email, you express concerns that the FD30S door set may not meet the full requirements of the building regulations. As the door replacement programme had already started, were you concerned that Abigail Acosta had begun a programme with doors that you were not confident were compliant with the building regs?
My understanding from discussion with Abigail Acosta and Janice Ray was that the FD30S door set approach came through a collaborative discussion between LFB, RBKC and KCTMO. I've said there I'm slightly apprehensive about that because my recollection at the time was that FD30S door sets had been set as the default. And my own personal experience, my knowledge was that an FD30S, as I stressed earlier on, is a minimum. There are instances where you might need to install something that is more than an FD30S. And it very much depends on the, excuse me, it depends on the particular arrangements in relation to where that door set is within the communal areas and their access onto a communal area, etc. And that was my apprehension there.
And it was a general apprehension as opposed to a particular concern that in the particular circumstances of a building, it wouldn't be compliant. Okay. At the time of writing this email, was it your understanding that the doors were being replaced because the existing doors did not comply with the building regulations?
My understanding, not having been involved in how that programme was constructed, was that there had been some prior survey work that had either come out of the FRAs or had come out of some what I class as ad hoc stock condition survey work that had identified doors, so these were flat entrance doors, or rather, I'll be clear, door sets, that didn't comply with the standard at this time, as opposed to the standard when the building was built.
Now, having regard to the fire safety considerations, would you agree that there's no good reason to differentiate between leaseholder doors in terms of priority compared to tenant doors?
From my personal perspective and my personal belief, all tenants should be treated the same.
And from the fire safety perspective, there's no reason to render leaseholder doors as a lesser priority than those of other residents.
Apologies, just to clarify. I shouldn't have said tenants, I should have said residents. So whether they're a tenant or a leaseholder, they should be treated the same.
And after providing the advice set out in your email of the 13th of June to Abigail Acosta, what steps did you take to ensure that leaseholders were informed of the need to ensure their flat entrance doors complied with the order? And when I say doors, would you forgive me, it's abbreviation for door set. You make a good point in that regard.
Apologies, for me it's a personal bugbear. There's a very technical reason behind that. Well, as you can see here, this is the starting point. I recall that and I'm presuming this is it, this was the start of internal dialogue around the approach that should be adopted for leasehold flats.
And so what steps did you take to ensure that leaseholders were reminded of the obligation to comply with relevant regulatory obligations?
My recollection is that I don't know when in relation to this it was, but there was to be written communication as well as personal visits wherever feasible with leaseholders, notifying them of this requirement, and also advising them of the options available to them.
Do you know now whether a response was sent to Mr. Mott or not, and what it said?
I don't know whether there was one sent or not.
Did you take any steps yourself to ensure that leaseholders were encouraged to come to a private arrangement with Mance Master Door for the replacement of their doors?
Beyond promoting the fact that that was an option that was available to them, and also advising them that it may be a more cost-effective solution for them. I think the other aspect of the cost-effectiveness was that from conversation with Daniel Wood, it was about whether or not we would be able to allow a leaseholder to spread that cost over a period of time. So that was we were exploring a lot of different avenues to make this more affordable for leaseholders.
Could we now turn to an email exchange between David Ward, who was a senior home ownership officer, and Abigail Acosta in September 2011, and that can be found at TMO 00868 and this is email correspondence taking place between the 6th and the 7th of September. And I'll just if the document manager would allow you just to see what's said there. Scroll down. Maybe, and then scroll up.
If you could leave it there.
Sorry. Sorry.
Stephen Mocklow is...
He was at Mance Master Door.
Thank you. Okay.
But really, the question is, were you aware that leaseholders would only be informed that they could approach Mance Master Door for a replacement door if they approached Mance Master Door directly?
I wasn't aware of that specific detail. I believe there was communication with leaseholders prior to this.
If we can just deal with this email correspondence, though, because I recognise that there's a lot of documentation about this, but just looking at this top email, the 7th of September, 1339, do you know why Mr. Ward directed Abigail Acosta not to send the letter to all leaseholders?
I don't.
Were you aware that that instruction had been given?
No, I wasn't.
Can you remember whether your approval was sought for limited circulation of a letter, or you were informed about it?
I don't recall this restriction at all.
Now, Mr. Ward wrote to leaseholders on the 11th of October 2012, so 13 months after this correspondence, and that can be found at TMO 00847 There you go. I'll just let you briefly have a read of that, Mr. Anson, so you know what's said.
Would you mind just expanding that? Thank you. Okay.
Do you know why there was a delay between the advice you gave in June 2011 and this letter of October 2012 about notifying leaseholders of the need to check if their front flat doors met legislative requirements?
I don't know the specific reasons for, as you'd said, a 13-month delay there almost. I did have an awareness that there were conversations ongoing with London Fire Brigade and Kensington Chelsea, Royal Borough of Kensington Chelsea Council, and at some stage, I can't recall exactly where it fits into the process, but the council's opinion was sought as well.
As interim director and later director, would you accept you had some responsibility to ensure that your recommendation was carried out and that leaseholders were given proper and timely notification of the need to check whether their flat entrance doors were regulatory compliant?
My recollection is that there was communication with the leaseholders in 2011. regarding flat entrance doors and the requirements. I don't know whether it was to this level of detail in terms of the certifier, FIRAS, etc. requirements.
Now, on the 14th of November 2012, Tunde Awadero wrote to David Ward on behalf of the GTLA after receiving Mr. Ward's letter of 11th of October that we see on the screen. Now, you were copied into that email, and we can find it at TMO 00837 229 /2. And we can see the start of the email at the bottom of the page, and the substance is on the final third page. Now, if you take it from me that the email raised 4 principal matters. First, the exclusion of leaseholders from the flat fire door replacement programme. Secondly, the failure to notify leaseholders for 19 months that their flat entrance doors may not be fully compliant with fire safety regulations. Thirdly, the TMO's lack of maintenance of fire safety systems at the time of the 2010 fire. And fourthly, a lack of consultation on improvements to the tower, in particular fire exit doors, unsafe building, smoke vent and smoke alarms, internal decoration and repairs. Now, having summarised that, I'll just let you refresh your memory of that email.
Would you mind scrolling down to the... Thank you. And again, please. Thank you.
I think the bottom of this page is probably as far as you need to go for the questions, Mr.
Okay, yep. All right.
In relation to the exclusion of leaseholders from the replacement programme, were you concerned to note that your advice of June 2011 to notify leaseholders had not been followed earlier?
I can't remember what my reaction was at the time on reading this, or what action I took in relation to that. Mindful
of your interest in promoting the availability of entering into an arrangement with Master Door, were you concerned or disappointed that that private arrangement option had not been pursued with the leaseholders?
It's very likely that I was, but I can't recall.
In relation to the GTLA's concern that they've not been notified of potential issues with the doors for some time, would you accept that GTLA had a legitimate concern about that?
I think GTLA, along with the residents more broadly within Grenfell Tower, had legitimate concerns. And on reading this, yes, I'd consider that a legitimate concern.
And would it flow from that? Were you concerned at the time that a number of leaseholders appear to have doors which did not comply with the relevant regulations?
My reading of this, and certainly the approach at the time, was the presumption was that all leaseholder flat doors did not comply. That's a presumption. And what was being asked was, these are the requirements you need to meet. Can you satisfy yourself and us that they do?
And I suppose asking a different question differently, were you concerned about the time that had been taken to ensure, mindful of the importance of doors set, the time that had been taken to regularise the situation?
Yes, that would have been a concern. I'm not totally convinced that there was no communication in a 19-month period.
Did you articulate your concerns internally at the TMO about the time this issue was taken, given the presumption that the doors did not comply with relevant regulations?
As I said, I can't recall exactly what my reaction to this was, or what actions I took in relation to this. I do recall that there were points in time where I had a need to engage with others in the organisation about reaching a position of resolution in this matter.
Can you remember why the GTLA was not consulted about fire safety and smoke extraction systems? Was it because they weren't originally they weren't originally intended to be part of the refurbishment programme?
As I said, I'm not totally convinced that there was an absence of communication with residents, and included in that is leaseholders and the GTLA over that 19-month period that's referenced here.
Looking at the substance and tenor of this correspondence, did it cause you to take a step back and ask yourself whether the fire safety systems at the tower were being adequately maintained, given the concerns that had arisen from the GTLA?
It may have done, but I would have also taken comfort from the fact that I was aware through my internal meetings, internal interactions with individuals within the team, that whilst there were some contractual challenges with GRE and their delivery and performance, that the servicing and maintenance of the AOVs and the smoke extract system were ongoing. That planned preventative maintenance was ongoing, whether that was the smoke extract systems, the fire alarm systems, the lifts, etc. And that was being recorded. So the visits were being recorded by the engineers within their daily diaries, their day books. The notes were being put onto their individual spreadsheets. Some notes were being input onto Academy, some were being put onto W2. So I'm struggling to marry those two up.
Okay. On the 14th of December 2012, Paul Dunkerton responded to Tunde Awadera's complaint about the flat entrance fire doors and the smoke ventilation system, and we can see that response at TMOH 000 27328. Just let you briefly familiarise yourself with the letter.
You scroll down to the next page, please. Don't worry about expanding it, that's fine. Well, certainly for me, that's fine. And the next section. Thank you. Okay.
Did you discuss this letter with Mr. Dunkerton before it was sent to the GTLA?
I can't remember it specifically, but Paul Dunkerton and I did have discussions around communications generally with all residents within Grenfell Tower and the surrounding community.
Were you aware before this letter was sent that RGE had reported in September 2011 that they could not guarantee the smoke ventilation system would work in the event of an emergency?
I don't remember the specifics of that one. I do remember having it generally fed back to me via it was either Keith Fifield or Ricky Sams, that there were a number of systems that were reaching end of life effectively. And whilst RGE were able to carry out ad hoc repairs on those, there may come a point where they broke down again beyond an ad hoc repair being capable.
And did you check whether those general concerns were relevant to the specific situation of Grenfell and the smoke ventilation system there?
Do you mean in respect of the incident in 2010, or?
No, in respect of, for the purposes of answering this letter.
Sorry,
reviewing this letter.
I would have guided Paul to have had conversations with his colleagues to make sure that the system was functioning at that point in time.
And in light of what RGE had said in September 2011 about the absence of a guarantee that the system would work, would you accept that this letter from Mr. Dunkerton essentially misinformed the GTLA about the state of the smoke extraction system?
No, I don't believe it's misinforming them. I believe your point is more. So RGE are saying that they can't guarantee it, and my recollection of the contractual requirement is that RGE were required to warrant any work they carried out for a 12-month period, and that that particular notification was in relation to their inability to guarantee that it would last for a 12-month period.
Would you accept that this letter left it still unclear to GTLA as to whether their front door needed to be replaced?
Yes, I accept that.
And it was also unclear as to how they could verify whether it was in fact necessary to replace their front door?
Apologies. Yes, I'd agree with that.
Did you try and ensure that it was clearer in those two respects, or were you content to leave the draft as it stood?
I can't remember the timings, but there were. I do recall there were separate conversations going on in relation to leaseholders' flat entrance doors in terms of what information should be provided to them, what guidance should be provided to them, where that guidance source came from. There was also, and again I can't recall when it actually happened, council's opinion about whether or not it was enforceable by KCTMO or not, etc.
But do you think by this stage GTLA were entitled to a straight answer as to whether their door needed to be replaced and how they could verify whether it in fact needed to be replaced?
It was certainly my view, well in advance of this, that leaseholders' doors and tenants' doors should be presumed to be deficient and therefore should require replacement unless the leaseholder could evidence otherwise.
And was that a view which you pursued in informal discussions internal to the TMO?
Yes.
Could I now ask you to turn to TMO 1001904? And Mr. Awadero sent a further email to Mr. Dunkerton with you copied in, and the email said in the second paragraph, and it's in the sort of bottom third of this page, in relation to your letter, we are confused as to whether the current doors are fit for purpose. He also asked for further disclosure of documents relating to the 2010 fire. Then if we reduce the page again, you sent an internal email saying you would draft a response for input. Why did you not want anyone else to respond? Sorry, your email's at the top.
Is there anything subsequent to the bottom of this?
Not on this one.
Right. I'm not totally sure. My presumption is that I felt this was becoming a very sensitive issue, and that perhaps up until this point we had not been as clear with leaseholders as we could have been.
Okay. Now, could we now turn then to TMO H 000026874? Now, this is in Mr. Dunkerton's name, but did you draft that letter, albeit it's dated the 30th of January?
I very much. Well, before I respond, if I could
read it before you respond, Mr.
Yeah.
Anson.
I'm just my hesitation is in relation to this is around the time that I left the TMO.
I'm just minded, it's responding to the email Mr. Arodero said, the one that you said you alone would respond to.
I appreciate it.
And so the question is, did you draft this letter?
Would you move on to the next part of this? Thank you very much. And the next section, please. I don't recall the specifics of this letter. I do know that I drafted a response. As I said, this coincided with my departure from the TMO, so there may be elements of this that I drafted. This could be a completely fresh response following my departure.
Would you accept that the letter did not answer GTLA's question about whether their front doors were compliant?
I'd agree with that.
Now, a final response on this issue was sent to the GTLA after you left the TMO. At that stage, when you left in January 2013, what was the extent of your understanding as to whether leaseholder doors were compliant at Grenfell Tower?
My understanding.
beyond your working presumption?
Yeah, right, okay. That we didn't know. We hadn't had access to the door sets other than a visual inspection from the exterior. So we didn't know. Hence my approach, which is a presumption they are non-compliant.
And given that you didn't know, given your working presumption, wasn't there every incentive to get on with the expeditious and full replacement of fire doors with regulatorily compliant door sets?
Yes, there was, and I believe that KCTMO was operating in that environment, but recognised that it had some potential legal obstacles in its way, hence the need to secure council's opinion about whether or not there was an enforceability around the replacement of doors, hence the discussions. I don't recall when they were, but there were discussions jointly with RBKC and London Fire Brigade about which party was the enforcing body. I recall there was I certainly attended one meeting where that was discussed and an approach was agreed.
Certainly mindful of that, but given the importance of door sets as a fire safety measure, would you accept that greater expedition, a greater sense of urgency should have informed the replacement programme insofar as it affected leaseholder doors?
I think the general thrust within KCTMO was to replace the doors. There were delays to being able to do that because there was the lack of clarity or certainty as to whether or not KCTMO was able to do that. And that then involved the conversations with London Fire Brigade and RBKC about whether or not there was a legal basis upon which that could be done, and if there was, which party was the enforcing body.
Would you accept that thrust suggests action, but no action was being taken? So do you think it was an appropriate description of the TMO's attitude?
No, I don't believe that was a reflection of the KCTMO's attitude. I draw a distinction between action being the door sets being replaced and action being an effort to, having identified that this is something that needs to be done, how do we legally deliver it?
Thank you. We can now move on to a separate topic, which is about emergency services access to the tower. And if I could ask you to go to an email from Mr. Ed Defan, 16th of October 2012, which is at TMO 00854874. Scroll down. Next page. And you see Mr. Defan's. If we go down further, that's a later email. Mr. Anderson, whilst that's going, do you recall email correspondence from Mr. Defan regarding emergency access to the tower?
I do.
Yeah. And may assist if we go to a response from Mr. Black, which can be found at TMO 1001725.
Could I just check that you didn't want me to read this?
I don't.
Okay.
Just to familiarise yourself with the general point. And here we go. So we've got at the top there a response, an email rather, from Mr. Black to Janice Ray. And says in the final paragraph, in terms of the rest of this state, as far as I can remember, Mark confirmed this is the responsibility of RBKC. So I'm not sure if we can do as she is asking. Can you review with Mark and then reply to her? Then if I can ask you to go to TMO 1001729.
Could I just check with you that this is in response to Councillor Blakeman?
Yes.
Yeah, thank you.
And then we see, you responded to Mr. Black and said you'd respond to all issues relating to calc and GTRP. That's in the bottom third of that page. And then if I can ask you finally to go to TMO 00845-602. And here we go. It's you're emailing Mr. Defan on the 26th of October at 8:49. And you say in the third substantive paragraph of that email, starts with the words, with regard to fire safety at Grenfell Tower, and for that matter, the remainder of the estate, and as advised at the Estate Management Board meeting, the fire safety and management arrangements form part of the respective projects, and at present there is no impact upon the access routes that LFEPA would utilise in the event of an incident. Now, taking that paragraph itself, on what basis did you satisfy yourself that there would be no impact at all on the access routes to the tower?
Would you mind just scrolling up on this so I can see the date?
Yes, it's the 26th of October.
Right, okay. So at this point, with the design evolution, in terms of where we had reached, the proposals for Grenfell Tower would not have any adverse impact upon the highway or the service routes into the estate and around, or certainly on two faces of the Grenfell Tower.
Was that a view you reached yourself, or was it a view that was reached in consultation with either Ryden or the LFB or Janice Ray?
Ryden were not involved at this point in time. They were
Sorry,
not,
yes.
This was Leadbitter. So this was in consultation with Leadbitter and the design team, or pre-construction professional team, I should use the correct phrase. So we had all discussed issues, discussed concerns, and we had all concluded that at that point in time, the design as proposed would not impact.
If I can stop you there, did you consult with the LFB?
There were discussions with LFB. I can't say whether that was in advance of this or post this.
Did you have any discussions with any other emergency services who might require emergency access to the tower?
We spoke with, it was the Metropolitan Police Neighbourhood Policing Team. I can't remember their exact.
And did you check what, if any, regulatory requirements had to be complied with in relation to emergency access before responding to Mr. Defan?
That was part of the as the design evolved. The pre-construction professional team were in dialogue with London Fire Brigade about the emergency vehicle service route.
And you relied upon their response for the purposes of responding to Mr. Defan?
Yes.
Did you confirm with RBKC? Did you confirm whether RBKC would be responsible for the roads around the tower?
The issue that was highlighted by Mr. Defan and others, both in the community and residents of Grenfell Tower, encompassed the public highway as well as the service road. And so it was in relation to the public highway that it was an RBKC responsibility at this date.
Thank you. And can you remember whether there was anyone specific at RBKC who's involved in these discussions?
I only recall that the pre-construction professional team spoke with the Highways Department, planning, trying to think who else they spoke with. Environmental was another one. I believe they had conversations with building control, but that wouldn't have been in relation to this necessarily.
Thank you. Can I now turn to complaint system questions, and nearing the end of my prepared questions, Mr. Anderson. By December 2012, residents had raised with you fire safety concerns in respect of maintenance of the smoke ventilation system at the tower, information provided to the leaseholders about checking if the front doors were compliant with relevant regulations, and emergency services access to the tower. Did any of those single complaints or taken in combination cause you to reflect about the adequacy and the integrity of the fire safety arrangements for the tower?
Throughout the evolution of the design, residents, be they tenants or leaseholders, observations, comments, complaints, whatever you wanted to categorise them as, were taken into account. And wherever possible, responses were provided to them.
But you were satisfied with the adequacy of the fire safety arrangements at the time?
I mean, there were certainly occasions where I was prompted to just check. Smoke ventilation is apologies. Smoke ventilation was one that does stick in my mind, because there had been reference a number of times to a fire in 2010. Now, I wasn't aware of a fire in 2010. I wasn't there at that point in time. But I did want to understand what had happened in 2010, because there'd been smoke logging on a number of the floors. And that was because the automatic opening vents had failed to operate correctly. They'd partially automated, but not fully. And I wanted to understand that had been addressed. I was satisfied it had been addressed. Yes, there were issues in terms of RGE's performance.
If I can just stop you there with RGE, yeah. Obviously they'd advised in September 2011 that they couldn't guarantee the operation of the AOV. You made the point that obviously they'd provide assurances in relation to 12-month periods. When the letter of the 14th of December 2012 was sent by Mr. Duncton, which you reviewed before it was sent, did you expressly ask for assurance from RGE that the smoke ventilation system would be effective in the event of a fire?
I can't recall if I asked specifically in relation to that response. I know there were a number of occasions, both in 2011 and in 2012, where through either Keith Fifield or Ricky Sams and their team members, that I'd asked the questions about where are we in terms of the fire alarm system, the dry riser servicing, the automatic opening vents.
And did you ask a specific question in relation to the operation of the AOV of Mr. Fifield, Mr. Sams, or Mr. Duncton before you signed off on the letter that Mr. Duncton sent out in December 2012?
I don't know if I used the term AOV, but I did ask about smoke extract.
Okay. The final section that I'd like to ask you about concerns disabled residents. And could I ask you to consider minutes of a meeting held on the 28th of March 2012? And that can be found at MAX 000 00008. Thank you. And if we turn to page 2 under the heading of additional consultants, it's under item 4. And you see the second point is possible disability consultant required. SE will approach consultant engaged on calc. Can you remember now what had prompted the discussion about the need for a disability consultant?
Yes, I can. So we were providing additional residential units, so they were new. That new provision, whilst the general thrust from both KCTMO and RBKC was that they should be wheelchair accessible, we wanted to ensure, or the pre-construction professional team wanted to ensure, that we were meeting disability standards.
And was there any discussion in the context of the refurbishment project of the needs of residents with restricted mobility to evacuate should the need arise? There
were some general discussions around that, and I recall the pre-construction professional team had discussions with London Fire Brigade and with RBKC Building Control about what the requirements were or would be for the remainder of Grenfell Tower, bearing in mind that this was a refurbishment project and might not therefore be captured by building regs that would apply at this date as opposed to existing accommodation.
And can you remember whether during the course of those general discussions there was any mention of any personal emergency evacuation plans for individuals who may have impaired mobility, for example?
I don't know when those particular topics came up. That might be a more appropriate question directed to the local estate management team.
Thank you. Mr. Anderson, that marks the end of my prepared questions. As you know from last time, there's now a period which allows me to check whether there are any further questions that I need to ask. Sir, might I ask for
The usual break.
the usual break?
Yes. How long do you think I should allow this time?
I'd be minded to allow 20 minutes.
20 minutes.
20 minutes at this stage, sir. That which should be more than enough, as that was.
Well, I think it would be more. I was going to say 15. Do you think? 15 to start with. Yeah, I think 20 minutes is more than enough, to be honest. I think we'll say 4:45, but if more time is required, we shall entertain the application sympathetically.
Thanks, sir.
All right. So, what all that means, Mr. Anderson, is we have a break. We'll resume at 4:45 or as soon as we can thereafter. And I have to ask you again not to talk to anyone about your evidence while you're out of the room.
Thank you, Mr. Chairman.
Thank you very much. Would you like to go with the usher, please? Right. 4:45 or whenever.
Thank you, sir.
Okay. Would you ask Mr. Anderson to come back in, please? Right, Mr. Anderson, we'll see if there are more questions for you.
Thank you, Mr. Chairman.
Mr. Anderson, thank you. Some further questions for you. During your time at the TMO and in relation to the refurbishment project, was any consideration given to issues regarding accessibility and the ability to exit existing flats in the building?
As I mentioned before we broke, the pre-construction professional team engaged with London Fire Brigade Building Control because they wanted to understand what the implications were on refurbishing an existing tower block, i.e. Grenfell Tower, and whether or not there were any requirements.
And can you give us a bit more detail with whom you had these discussions?
I didn't have those conversations. That was the pre-construction professional team.
Mr. Anderson, in those circumstances, those are all the questions I now have for you. It just leaves me to say, finally, if there's anything else you'd like to say which you think would assist the panel in its deliberations.
I'm more than willing to provide further assistance if you require it. I can't think of anything at this stage. Again, I offer my sincere condolences to all of those affected by the fire that happened on the 14th of June 2017.
Yeah, thank you.
Mr. Anderson, thank you for coming to give evidence.
Thank you very
Well,
much.
Mr. Anderson, it just remains then for me to thank you very much on behalf of all the members of the panel for coming along for a second time to give evidence. It's been very useful to hear from you, and we're grateful to you for coming. But that is all for the afternoon. Thank you very much.
Thank you, Mr. Chairman, panel members. Thank you.
So, Mr. Kinnear, that brings us to a close for the day.
It does, sir.
And we don't sit tomorrow, so we shall resume on Monday of next week,
So, yes.
10 o'clock, when there are more witnesses for us to hear.
There are two more witnesses who will be taken by Mr. Gadd.
Good. Thank you very much. 10 o'clock on Monday, then,
Thanks,
please.
sir.